I want to get an update out for you guys before we head into the weekend. In the Macon County case, an attorney's confident the final judgment issued applies statewide against Illinois' gun ban. So just put this together. Attorney for the state representative Dan Calkins says he's confident a final judgment against Illinois' new gun ban issued by a Macon County judge Friday is statewide. This is the case that was brought by Calkins in Macon County. If you recall, the Macon County case followed several other cases that were brought by attorney Thomas DeVore. He had one in Effingham County where a temporary restraining order was issued for about 866 plaintiffs in that case, and then that was appealed by the state. The Fifth Circuit Appellate Courts upheld the temporary restraining order, and then you had temporary restraining orders essentially fall into place from there, including this fourth case in Macon County from Dan Calkins. Now, the three DeVore cases, those are separate, those are consolidated. The Macon County case went forward, and there was an agreed order entered. Of course, State Representative Dan Calkins versus Governor Pritzker, and the agreed order essentially highlights that the Fifth Circuit Court of Appeals must be followed by the district courts. And while the state says they don't agree with that appellate court, they acknowledge that the district court, the county court, Macon County Court, has to abide by that order. So the Macon County judge went ahead and said, because of that, they are ruling that the final judgment is in this Macon County case that the state law is unconstitutional. Now, what that means is it's unconstitutional, according to Jerry Stocks, who says he's confident that means it applies statewide. I was able to catch up with Stocks briefly. Here's some of what he had to say at the Macon County Court Friday before the judge issued the order.
A judgment that a law is unconstitutional, we submit, would be void as if it never existed and would be unenforceable in all applications, in all respects, and that would mean statewide. The state is not going to concede that point, but the order will have its legal impact. And the best advice I could give there is that I'm pretty darn confident as to what its scope is, because a circuit judge can enter a judgment that applies across the state. For example, if I'm convicted in Macon County, it doesn't mean I'm a convict only in Macon County. I'm a convict in the entire state of Illinois. But the state, and in fairness to the position they want to express, says this would only be related to this case. Well, if a law is unconstitutional, it's unconstitutional. And I would not want to be in the position of any law enforcement ever enforcing a law that has been adjudicated unconstitutional because their insurance carrier for 1983 liability is going to be doing handstands and flips. The other reason is the state needs to move this quickly once a judgment's entered because of that particular question. And we need to get it resolved.
So again, that was Jerry Stocks, who represents Dan Calkins, saying that he's confident that the judgment in Macon County, a final judgment that the state's gun ban is unconstitutional, applies statewide. I've reached out to the Illinois Attorney General's office and also the governor's office and have not gotten a reply. Of course, we will be watching that closely, but expecting an appeal to the Illinois Supreme Court. So follow me on Twitter. You can also find me on, of course, YouTube and Facebook, and you will be able to stay up to date on the very latest. We'll be live with a whole lot more of what both State Representative Dan Calkins and his attorney Jerry Stocks had to say on Monday. So have yourselves a great weekend. Thanks for all the support. Thanks for everybody reaching out. And you can always find me, again, bishoponair.com.